Going AWOL. We'll try that again. Welcome to today's webinar, which is on what a human rights-based approach means for your organisation. So my name is Janelle Rees and I am the Sector Sustainability Coordinator at Community Legal Centres Queensland. Before I get started, I'd like to acknowledge the traditional owners of the land on which we are holding this webinar today. I wish to pay my respects to their elders past, present and emerging and acknowledge the important role Aboriginal and Torres Strait Islander people continue to play in our society. As this webinar is being viewed by people across Queensland and Australia, I'd also like to pay my respects to the traditional owners of the land throughout the country and extend a warm welcome to any First Australians listening today. So today we are joined by Ben Schockman. Ben is an experienced human rights lawyer and spent 10 years at the Human Rights Law Centre in Melbourne. I'll let Ben tell you a bit more about himself when I hand over to him shortly. So today's webinar is being recorded and we'll have the recording available to download later today. The PowerPoints and other materials have been emailed out to everyone who registered and they'll also be available to download from our website. We'll hold questions until the end of the presentation, but feel free to type them into the questions box as you think of them, and I will look after that and read them out for you at the end. And Ben will also be running a few polls today, so please make sure you put your answers in when they appear on the screen. So I will now hand over to Ben, and I'll talk to you again throughout the session.
Great, thanks very much, Janelle, and good morning, everyone. I'm just going to double check, Janelle, that my screen's there for everyone to view.
Yes, it is.
Great. Well, thanks for that introduction, and can I also please add my acknowledgement. I live and work down in Melbourne on Wurundjeri land, so I'd like to acknowledge traditional elders past and present here in the Melbourne context as well. And just briefly on that context, I am a Southerner, so I'm conscious that I'm providing a webinar today to people focused on the Human Rights Act in Queensland. So I just want to maybe add the context or the caveat that my experience has been in the Victorian context with the Victorian Charter of Human Rights and Responsibilities down here. As Janelle said in the introduction, I had the privilege of working at the Human Rights Law Centre for about 10 years, and one of the key focuses of the work that we did was obviously on the sort of successful implementation and operation of the Charter in the Victorian context. So I acknowledge that obviously many Queensland laws are different, and while the Human Rights Act is modelled on legislation like the Victorian Charter, just want to also acknowledge that obviously it's different legislation, and I'm speaking from a Victorian experience. So with that sort of introduction, I thought I might just get straight into today. The screen's working, which is good. So just a quick overview of the purpose really for today's webinar, which is to explore how the Human Rights Act can be incorporated into your organisation's key operations. The webinar is directed at community legal centres, but I'm conscious that there's lots of people who are attending today that don't necessarily work in CLCs, so I'll bear that in mind as well. I should say it is great to see that there's been such overwhelming response to the topic of today's webinar, which is, I think, wonderful and appropriate given the significant importance of the Human Rights Act. So what we propose to do today is just talk briefly about the benefits of adopting a human rights approach, what obligations might CLCs and other public entities have under the Human Rights Act, but really get into a few, I guess, practical nuts and bolts really about what the Human Rights Act might mean for things like organisational policies and procedures, and things like building a human rights culture, both within your own organisation, within the work that you do, and within the broader communities that you operate in as well. So just to give you a quick sense, I wanted to start just by providing a few observations from what's happened in other jurisdictions with similar legislation to the Human Rights Act. I don't propose to talk too much about the key operative provisions of the Act itself. Hopefully people are at least at a high level reasonably familiar with those. But as I said, I really want to get into what might be some key considerations for CLCs and more broadly some of the other community organisations that are attending the webinar today. So I'll try and talk about a couple of practical examples that we go along to put those things in context for everyone, and then I just want to flag, and I'll mention a little bit more at the end about a toolkit that CLCs Queensland has been preparing, that Janelle has led, that's up on the website. So I'll flag that there is some work that's been done and a resource to help CLCs through that, and we'll talk a bit more about that towards the end. So just to give you a quick context, we're already a few minutes in. I propose to talk maybe for 35 or 40 minutes, and then I'm conscious that there might be lots of questions. So feel free to flag some questions along the way, and hopefully there'll be a bit of time at the end to respond to questions that people have as well. I might just throw back to you now, Janelle, for a couple of quick polls that we wanted just to run at the beginning.
Fantastic. Okay, so I'm going to launch the first poll, and this is about rating your knowledge of the Human Rights Act. So let us know what level of knowledge you have about the Human Rights Act in Queensland. So we will keep it open for a few more seconds. The responses are coming in thick and fast at the moment. All right, 10 more seconds. Okay, wonderful. All right, I'm going to close the poll now. So we have a good spread. We've got 2% of people recognised as an expert, and the bulk of people are sitting in the familiar and aware category. So we have a second poll to do as well, which I'm just launching now. So how much thought have you or your organisation given to the Human Rights Act and its application to your organisation? And again, they're just coming through at the moment. Looking pretty good for the quite a bit. All right, I am going to close that poll now as well. We have 51% of people saying quite a bit, which is fantastic, and 33% of people at a bit, with 16% at not much. So that's some excellent results coming through there. Over to you, Ben.
Super. Thanks, Janelle, and thanks so much, everyone, for doing that. That's really helpful for me to get a sense of, people in the webinar and where everyone's sitting. Good to know that there's a couple of experts who should be on the Human Rights Council in the webinar. That makes me just a bit more nervous about delivering the webinar, but that's all fine. So to jump into some of the detail, I thought I'd just start just with a couple of key messages. Particularly if people are busy and getting distracted, you can just read the key messages and then tune out if you like to as well. But I just really wanted to start by making a couple of probably quite clear but high-level points. The first is that community legal centres, just through the nature of the work that they do, are already really familiar with human rights. They might not necessarily use the language of human rights. A lot of you do. But just to make the point that the Human Rights Act, while it's an important piece of legislation, in some ways really enshrines rights and ideas, and in terms of the way that it relates to policies and procedures in organisations, things that CLCs already inherently do as part of their work. The second point really, and I'll talk briefly about the idea that adopting a human rights approach and the lessons from other jurisdictions have demonstrated that what human rights protected in law does is it plays a really important role to enshrine really basic principles of good policy, good decision making, and effective service delivery. And then I guess maybe just a few cautionary words that based on experience in other jurisdictions, while there have been lots of great success stories and examples of where public entities, government agencies and departments have been able to adopt really great human rights approaches, as have community organisations. There have been some challenges, and a lot of those really relate to low levels of engagement or understanding of human rights, both within organisations themselves, but also within the communities in which we operate. So that's certainly one challenge, and it's a great thing that everyone, as obviously there's been so much interest in this webinar and in other training sessions that have been running in relation to the Human Rights Act. And then the final point to make, and no doubt this might come up a little bit in some of the discussions today, but there is some legal complexity about some of the key operative provisions of the Human Rights Act, and that leads to I guess some challenges for people within organisations to think through how the Human Rights Act applies for them. It also leads to challenges within, I guess, the communities and the clients for which community legal centres and other organisations work. So I just want to sort of flag some of those key messages to begin with. Just to get into some key lessons from other jurisdictions, I know in the Victorian context, one thing that we did quite a bit was looked to the UK. There was a Human Rights Act that was introduced in the United Kingdom in 2000, so that was about 6 years that preceded our Victorian experience, and so we looked a lot to lessons from other jurisdictions, and as well as doing that, a lot of the observations that we found that applied in the Victorian context were really around how embedding human rights principles of freedom and respect and equality and dignity was really able to be done across a broad range of organisations, and those that were able to do that had some really great insights and successes in terms of prompting early identification of potential human rights issues. So in other words, issues that were coming up using the language and the idea of human rights enabled organisations to look at a whole lot of issues in a different light, to notice issues that were coming up in different ways. It resulted in more flexible and responsive service delivery, precisely because human rights principles require taking into account the individual sort of needs and circumstances of people. And one of the things personally that I find really, really helpful in terms of the human rights framework, and I'll talk about this a little bit more in a moment, but really the limitations framework is that it can help decision makers to make decisions often in contexts where previously they didn't have much of a framework. So decision makers who had either broad discretion or not that much guidance on how to actually make decisions in kind of day-to-day contexts, in specific contexts. The human rights framework gave them a really clear, commonsensical framework that basically meant that they could make better decisions, that meant that services were more sort of responsive and tailored to individual needs and circumstances. So I think it's sort of important to highlight some of the benefits of adopting a human rights approach, and I think that a lot of those lessons are particularly salient for community legal centres, where if you think about what we want to achieve through the services that we deliver, if it's more efficient and more effective services that better respond to client needs, then that's obviously a core element of the success of community legal centres and indeed other community organisations. So I won't talk to the Human Rights Act, the sort of details of how it operates in any great detail, save really just to mention that some of the key purposes of the Human Rights Act really are to build a human rights culture that's specifically provided for in the legislation, and this idea of promoting a dialogue about human rights. And so that's obviously very, very central to the topic of what we're talking about and the role that community legal centres and community organisations can play in fulfilling the purpose of the legislation. Just a very quick sort of overview or recap for the number of people who identified that they sort of weren't as familiar with the Human Rights Act. Generally speaking, what the legislation does is it imposes a range of different, or imposes maybe is a good word or not, but it requires a number of different mechanisms to operate across Parliament and the way that Parliament operates across the executive area of government, and then also in relation to the courts. And what really we're focusing on today is the obligations that are required for the executive arm of government. So in other words, government ministers, departments, other agencies that effectively play the role of government or deliver services on behalf of government. So very quickly, just in terms of the legislation, so what the Human Rights Act does is it imposes, I'll start with the definition. It sets up this term called a public entity, which is defined in the legislation, and there's two categories of public entities. So one is what are called core public entities. So that is, I guess, what we would all associate with government. So it's government ministers, government departments, public officials, agencies like, or institutions like the Queensland Police, local government, other statutory bodies, and they're all specifically enumerated in the legislation. There's then this other funny little definition called functional public entities, and this is really the nub of where community organisations and other agencies sit. So this idea that functional public authorities really are entities, so agencies or organisations that are performing functions of a public nature, essentially on behalf of the government. So there are some agencies for whom that's going to be really, really clear. There are other agencies and organisations where it requires a bit of an analysis about where the funding sources come from, how highly regulated the sort of terms of that funding are provided. So this is really where it's an interesting question about community legal centres and whether or not they might be captured by this definition of a functional public entity. I think the clear answer is there's probably not a clear answer about whether or not CLCs themselves are classified as functional public entities. There's a good chance that for some specific aspects of CLC work where there's funding that comes directly from the Queensland government, where it's for services that are highly regulated, that there could be aspects of work that CLCs that fall under the definition of a functional public authority. That could also be the case, and there's probably people that have given some more detailed consideration to this where CLCs aren't. But I guess the broad point to make for today's purposes really is to reiterate what I said earlier around the idea that the promotion of human rights is entirely consistent with the purpose, the ethos, the practice of many, many CLCs. And in fact, many organisations already incorporate a very strong focus on human rights and human rights principles, either overtly or using other language into the work that they do on behalf of clients. So in lots of ways, I think the Human Rights Act can be seen as this opportunity to actually focus on how organisations can actually better adopt a human rights approach to deliver the benefits that I talked about earlier. Just a final couple of words to say about the Act itself before we get into some of the hopefully more relevant content for CLCs thinking about their own internal organisational approaches. Really just to clarify that what the Human Rights Act does is it imposes an obligation on public entities to do two things. So one is to act and make decisions compatibly with human rights. The other is to give what's called proper consideration to relevant human rights. So you can see straight away that there's both a substantive obligation, so in other words, to act and to do things that are actually compatible with human rights. The second element is more of a procedural obligation. So it's actually going through the process when making a decision or designing a service or responding to a client in some way. It's actually going through the process of giving proper consideration to human rights. So that really essentially requires giving consideration to human rights, literally in a day-to-day context, in decisions that are made, in how clients questions or seeking access or assistance, how they're responded to on a daily basis. So just to get it into some of the substance, some of the questions that I know that have come up in other contexts really are sort of around this idea of how do we identify human rights issues. The Human Rights Act itself obviously outlines 23 various rights that are protected in the legislation. It's not expected that everyone is a detailed expert on the meaning and content of all of those rights. But one useful tool that has been adopted is this idea of kind of the Touchstones, this acronym that's called FRED. So using these principles around freedom, respect, equality, and dignity. And if something comes across your desk, if a client comes to you or you're looking at making a decision in some way, and the issue before you touches on some element of freedom or respect or equality or dignity, then it's highly likely that human rights are going to be relevant to the work that you're doing. So it's almost an indication really that if some of these principles come up in the work, then that's the way to identify that there may well be human rights concerns that are at play. And that's an indication really as a decision maker that you need to look a little bit further into it. So you can see there I've sort of very roughly sought to group the various rights that are protected in the Human Rights Act. Some of them, will fall under various categories, but hopefully that helps people just to get a sense of how to identify human rights where people might not necessarily be comfortable or conversant with human rights language at the moment. And then a very just quick observation or comment really on this idea of limitations on human rights for people that perhaps aren't as familiar with the content of human rights. There's this idea that human rights can be limited in certain circumstances. So what we see playing out, for example, a lot at the moment is this, balancing act that needs to happen between a right like freedom of speech and something like the right not to be discriminated against. So in terms of how those rights play off against each other, one doesn't trump the other, rights don't trump other rights. There's always this idea that a balancing act needs to be happen. So rights can be limited in circumstances where it's reasonable and justified to do so. So I won't go into too much detail on that, but just to highlight really that when it comes to some of the aspects that we'll discuss about how to incorporate it into your organisation, that this idea of building in this process, thinking about the procedural obligation to give proper consideration to human rights, building in this process for how rights are considered within your organisational sort of policies or procedures. So to turn to, I guess, some of the more specific aspects of the work of CLCs, what I thought it would be helpful to do would be to highlight a few different areas where I think it would be helpful for community legal centres and indeed community organisations more broadly to think about where and how the Human Rights Act may have some impact and some considerations for how to look at adopting or enhancing, if you're already doing it, a human rights-based approach within your organisation. And some of the things really that I'll talk to are giving some consideration to whether or not there can be more explicit inclusion of human rights language and human rights concepts in some of your current approaches or policies and procedures. But also this idea that using human rights can be a really useful process to actually revisit the current approaches to the work, maybe some of the priority areas that you do, whether or not there could be new or different approaches to the priorities that your organisations take. So I'll start with talking about organisational strategy. So what I mean by this really are sort of high-level vision and mission statements, documents like your organisation's strategic plan. Something to consider really could be if your organisation doesn't already do it, is whether or not the sort of more explicit language of human rights or human rights concepts can actually be worked into either a mission statement or within your strategic plan. So as I mentioned, this idea that having a look at current priorities, let's say, for example, you're a disability-focused organisation, whether or not some of the priorities that you're looking to pursue could be enhanced, could be changed with the actual introduction of the Human Rights Act itself. Another thing to think about, just thinking about one example with some homelessness organisations in the Victorian context, I think they'd always thought that they represented the voice of people experiencing homelessness particularly well, but what revisiting their policies and procedures under the Charter in the Victorian context meant was they actually formalised advisory groups. In the homelessness context, there were other groups that did that in the disability context. So some consideration could be given to whether or not human rights principles can change the way that your organisation might think about some of these elements. If you're not already doing it, embracing the language of human rights and concepts of human rights could apply to organisations that do focus on particular areas. So, for example, disability organisations could consider looking more into things like the Convention on the Rights of People with Disability. Aboriginal and Torres Strait Islander organisations could look at the UN Declaration on the Rights of Indigenous Peoples to see whether or not there's specific elements of those treaties and documents that could be incorporated into the work that you do. And I guess just to flag that there are a range of other organisational documents. So you could look at reporting on either the Human Rights Act specifically or a focus on human rights within things like your annual reports. How does it interact with your business plan? How do you talk about human rights in newsletters, in social media that you do, and those types of things? So there, I guess, a couple of thoughts about how the Human Rights Act could potentially apply at that organisational strategy level. And I've already touched on a couple of those examples, but I know there was one community legal centre in the Victorian context who actually explicitly adopted implementation of the Victorian Charter of Human Rights as a key focus area. So they added that explicitly as a key focus area within their strategic plan, which obviously gave more direction and more consideration to how that would be incorporated into the organisation's work. It also meant, importantly, that when it comes to reflecting and revisiting your strategic plan down the track, that you're also looking back to think about whether or not human rights have been incorporated into the work of your organisation. So, organisational policies and procedures. This is probably one of the clearest areas where the Human Rights Act may have particular relevance. I know CLCs, Queensland did a bit of a scoping exercise to consider the range of internal policies that CLCs have or are required to have. And there's a few that have just been listed on the slide there. So policies like access and equity policies, eligibility criteria for clients who are accessing your services. Consideration could be given to how human rights may impact either on the content or the process around which decisions are made under those policies. Privacy and confidentiality is a pretty clear one. There's a specific right to privacy that's contained in the Human Rights Act in Queensland. So perhaps revisiting your current privacy policy to ensure that it encompasses that right to privacy contained in the Human Rights Act as well. Codes of conduct for staff, diversity, inclusion, other cultural competency policies are all, I guess, the range of different policies where human rights are obviously going to be particularly relevant, and where the Human Rights Act may have some work to do. And then the other thing to consider might be actually specifically including a human rights policy, whether it's just something like a general statement of principle of support for human rights, or something a bit more detailed. That's something that could be given consideration within your organisation. And I guess some of the real questions to consider would be whether or not policies actually limit rights in some circumstances. So one of the clearest examples really is around eligibility criteria, which is obviously a big factor for community legal centres and how you make decisions about which clients you are able to assist within resources and which clients you're not able to. So clearly whether or not you're making a decision to provide advice to a client or not to provide advice it is a decision. It's a decision that has human rights consequences, and there are relevant human rights at play, whether it's from a discrimination perspective, from an access to justice perspective, and right to fair trial perspective or otherwise. So that's probably one of the clearest areas where at least, I'm not saying that you need to change your eligibility criteria necessarily. Quite often the way that decisions are made are entirely compatible with human rights in any event, but probably just in light of that procedural obligation that I mentioned earlier, going through the process of demonstrating how human rights are considered in those types of decisions. Also acknowledging that there are many positive actions that community legal centres and other organisations take, outreach to particular groups, whether it be, say, culturally and linguistically diverse communities or geographically diverse communities, as an example. Interpreter services are all examples of where positive steps are taken to give effect to, whether it's access to justice or non-discrimination type approaches. I guess finally, and this is maybe one of the slightly more technical points, but just to highlight that point that I've mentioned a couple of times, which is really considering whether or not your policies outline how proper consideration is to be given to relevant human rights in decision making. So you could consider actually whether you pick up some of the wording in the limitations sort of clause or analysis that I mentioned earlier as a way to enshrine that in decision making within your organisation, and even looking at things at how exceptions might be worded. One of the kind of key elements of operation of a human rights based approach really is that if you've got any blanket or inflexible rules that don't allow for discretion or for individual circumstances to be taken into account, that's often where many human rights questions will arise. So thinking about how those types of policies are worded within your organisation. Thought I'd mention specifically complaints, both the process for how complaints might be made against your organisation, but also how they're handled. There's specific provision within the Human Rights Act for a human rights complaint to be made to the Queensland Human Rights Commission. That process requires that a complaint has to be made in the first instance to a relevant public entity. So in circumstances where CLCs may be regarded as being a public entity, I guess going through this idea of thinking about whether or not your complaints process is available, is accessible to different groups, both in terms of information being made available about it, but also for particular groups such as people with disability or people who might have English as a second language. Questions around how complaints are actually handled, is there sufficient independence and transparency, and whether or not you may need to make kind of specific reference to the Human Rights Act in either the information that you make available or in the way that you handle the complaint. So that's, I guess, just to make that point, there might be particular questions about the complaints process. I mean, I would imagine, I would hope that CLCs in particular already have complaints processes that fulfill all of these various elements, so it's probably just a matter of revisiting those to consider some of these high-level questions. So I've talked a little bit about organisational strategy. I've talked about internal policies and procedures. I'm sure, as many of you know, you can't really just focus on policies and procedures and organisational documents. There's more that needs to be done in terms of building a broader human rights culture within your organisation. Really building in that human rights culture, it goes without saying, is essential to how to deliver on a lot of the elements that I talked about at the beginning in terms of the benefits of adopting a human rights approach. So there's a range of different things that if you haven't already done within your organisation could be looked at. They range from building into staff position descriptions and performance reviews elements of other human rights broadly, or if it's a role where the Human Rights Act might be specifically relevant, building that in there. Guides for staff, board member volunteers. I mean, these could be things like induction processes or other guides in terms of how to respond to clients or other things that are developed. So think about how to incorporate human rights principles into those documents. A focus on things like staff training and education, webinars like this, but ongoing professional development to keep abreast of other developments that are happening within the Human Rights Act itself once it comes into operation and how that evolves, but also how your organisation evolves as well. One really clear way to do that can be to build into staff meetings or even regular catch-ups around client reviews, trying to build in a standing item agenda around whether it's the Human Rights Act generally or human rights more broadly. And I've listed there a couple of other ways to think about that, whether it's developing an actual communications plan, both internally but also externally through things like social media that I mentioned previously, how human rights are built into community legal education. That's, I think, a really important thing for community legal centres to think about, is how to increase awareness and understanding within the community around the Human Rights Act and how that could be incorporated into current CLE processes without having to embark on a whole kind of new program, but how it can actually be streamlined alongside existing CLE activities. And then really just to mention, as I mentioned briefly earlier, the idea of monitoring and evaluation as well. A couple of specific examples of how some organisations that I know have been able to really embed a human rights culture. So one was a CLC in the Victorian context that actually they developed their own database. So I won't delve into the whole class mess, but what they were able to do was actually build into their own database when they responded to client inquiries and the advice that they did, whether or not there were human rights that were relevant to that inquiry, and if so, what rights. That was a really valuable process, not just to support things like the early identification of human rights in terms of client concerns that come up, but it also built the familiarity of staff with human rights and human rights concepts. And then down the track, it also ended up being a really useful sort of evidence base when the review of the Victorian Charter, for example, came around, the 4-year and 8-year review, that there was some good data and evidence around what type of inquiries were coming in for the population group that CLC serviced. There's another really great program specifically that was implemented under the Victorian Charter of Human Rights called Human Rights are Aussie Rules. So this is obviously the down south context, and whether or not something could be done in a rugby league or other context, but it was basically a community education program within schools and other community groups where it used the principles of sport around participation, equality, freedom and those types of things to do community education around human rights. That was a really successful project. And then there were a large number of organisations that did things like develop client rights and responsibilities brochures and other things like that, which helped to both build the competency of clients to understand their own rights, but also meant that there were I guess in the spirit of that human rights dialogue, but more conversations that would happen with staff as well. So it helped to build a human rights culture, both within the organisation, but also within more broadly the communities in which those organisations were working. So thought I'd also just mention briefly the question around advocating for clients. The purpose of today's webinar is not really to talk about how to use the Human Rights Act as an advocacy tool. That's hopefully something that you're already thinking about, but I thought I'd just list a couple of thoughts or ideas about how to build that into the approach that organisations take. So it's thinking about through things like whether it's policy work, so writing submissions to government, you know, or other work that's being done, considering how you can actually build in explicit mention of the Human Rights Act into that work. So, for example, one organisation, and I know what we would do commonly at the Human Rights Law Centre is that for every policy submission that we did to the Victorian government, there would be a section that outlined obviously the obligations under the Human Rights Act and what rights were relevant to the submission that was being made. So it sought to really embed that in both the policy work of the organisation, but also in the content and the submissions that were being made to various government departments or decision-making committees. And also, if you're not already doing that, but obviously thinking about in engagement with decision makers, whether it's ministers, whether it's the public service around advocating for clients on a more day-to-day level, really building in questions around whether or not those decision makers have given proper consideration to human rights. And in fact, one of the simplest examples of advocacy that I can remember undertaking in relation to a prisoner was just writing a letter in relation to a client who'd been put into solitary confinement and essentially just asking the question, could you please explain how you gave proper consideration to human rights? And within receipt of the letter, the decision had been reversed and the client was moved out of solitary confinement. So I think there can be some really useful ways in which building into the daily engagement in the work that you do for clients, that you can be asking questions around the Human Rights Act there. So I think that covers off the other final thing, which builds maybe on the element of the database, but I guess just flagging for people now to really start trying to collect stories and case studies of where you've been able to advocate for clients and have had successful outcomes. That's going to be especially crucial when inevitably the time will come when the review comes around and having to demonstrate the benefits of the Human Rights Act. I think it's also really beneficial to collect stories about what you've been able to do organisationally and the changes that's made, once again, to demonstrate the benefit of the legislation. And I know certainly from our experience, while we thought generally about it when the 4-year review of the Charter came around, it coincided with a change of government, and we were on the back foot really in terms of having the evidence and the case stories, the case studies, the stories to be able to demonstrate the beneficial impacts that we'd seen, but we hadn't really collated that data and therefore didn't have a way to talk about it especially clearly. So that was the majority of what I wanted to cover in the content of the webinar. I flagged at the beginning that CLCQ has developed a toolkit for CLCs that's available on their website at the link there that's on the slide. I just want to flag that that's very much the first edition. Obviously, the Human Rights Act hasn't come into force yet. The purpose of that really is to get some of the key considerations out there for CLCs and other organisations for whom it might be relevant. So we're certainly interested in receiving feedback about that document. If you head to that link, you'll also see that CLCQ has produced a range of other sort of resources that are available on that page as well. So finally, I guess a quick recap, just in terms of the key messages to highlight once again that I'm super conscious that organisations will already be really familiar with human rights concepts, will probably already be adopting them, but it might just be a matter of considering how explicit or otherwise the Human Rights Act and human rights language is used. That there are a whole range of really clear benefits for adopting human rights-based approaches for your organisation, and to highlight again really that there are some challenges, but by taking some really quite small but important steps within organisations and within the work that you do with communities, that can go a long way to building a human rights culture within your organisations and the community more broadly. So listed there a range of different additional resources. I think everyone's received a copy of the slides, so I'll leave that with you. And I think, Janelle, I might throw back to you. There was one last poll that we thought would be useful to take before I'll open up to questions.
Wonderful, thanks Ben. Okay, just launching the poll now for you all. So just with regards to more detailed training, whether people would be interested in a more detailed workshop, not just necessarily about compliance, but also in the new year about using the Human Rights Act as an advocacy tool. Awesome. I'll just leave it open for a couple more seconds. Wonderful. All right. Thank you, everyone. We've got 3/4 of people saying yes, please. So that's some great feedback to have. And Ben is available. We've got about 10 minutes for questions. So if you want to type those into the question box, then I can read them out for you. While you are doing that, we've had a couple of questions come through in advance. So Ben, the first one is about the relationship between the Human Rights Act and how it could apply in the domestic and family violence jurisdiction.
Sure, thanks Janelle, and thanks for the question. I think it came from someone who worked within the court context. I'll just flag that obviously I'm not familiar with the specific sort of legislation relating to the domestic and family violence area, but I'd make probably the general observation that, well, a few general observations. One is that courts and tribunals who are considering applications or for particular orders have obligations to give proper consideration to human rights. So that applies particularly in the way that legislation is interpreted. There are obligations that rest with, if it's in the context, for example, of either police or government public officials who will be seeking orders to both act compatibly with human rights and to give proper consideration to human rights. So you can already see that there's a couple of different sort of access points, if you like, for where using human rights arguments can potentially be relevant. Without being specifically familiar with the legislation, I'm not clear about how what's the word, but how sort of predictive, if you like, decision making is under those legislation, those pieces of legislation. But if, for example, there are broad discretions that are granted either to the individuals who make the application for those orders, or courts in terms of whether they agree to those orders, then where there are areas of greater discretion for a decision maker and less sort of specific guidance that's dictated by the legislation itself, that's where there's opportunities to build in you know, the circumstances of individuals and how decisions could be made differently. And obviously in the family violence and domestic violence context, there are a range of very, very important rights considerations, particularly for vulnerable victims, survivors of domestic or family violence. So I'm sorry I can't answer that question in any more specific detail, but hopefully it'll give you a little bit of direction for the points at which the Human Rights Act might be relevant and could be used.
Awesome, thanks Ben. Another question is, where does conflict of interest fall for clients who are trying to access disability advocacy in a CLC environment? And does the conflict of interest override the Human Rights Act?
Just trying to understand, maybe, I don't know if there's a specific kind of context for that particular question. I mean, I think in terms of, so a general comment about conflict of interest, I think I'm not sure how specifically relevant the Human Rights Act might necessarily apply to that. I mean, that's obviously in the area of conflict of interest that's governed by other laws and is an important area. I mean, there could be elements where privacy comes into it. But to the broader question, if I'm understanding it correctly, Kate, I think a conflict of interest doesn't override the Human Rights Act, but it may well be that there are principles, rights within the Human Rights Act where that can provide further guidance as to how you might either see a conflict of interest that arises or how you actually might deal with it. I don't feel as though I've responded to that question particularly well at all. I'm sorry.
Oh, that was great, Ben. We can definitely take it on notice as well and see if we can find out more information about it. Okay. So we have, I'll just take one of the questions that were emailed through previously, and I promise that this one didn't come from me, but how do we link the need for climate action with the human rights perspective?
Yep, so great question. It will require, I'm just noting that a lot of these aren't within the context of embedding it within your organisation, but I'll answer it maybe quickly. So there's lots of really important resources on the human rights impacts of climate change. So what it really would be requiring is undertaking more work really to use the language of human rights and how they're relevant to climate change impacts in conversations with decision makers. So, I mean, I'm just kind of making it up, but if it's in, for example, conversations with your Queensland equivalent Department of Environment, Sustainability, or whatever it is that it might be, there could be work that's done either at a policy and submission level to actually talk about the development of policies or decisions that are made and how human rights are relevant to those. I guess maybe that's as good as I can answer that question. But yeah, I mean, in terms of a whole range of aspects of the impacts of climate change, I'd really encourage you to, rather than talk about human rights generally, is to use a lot of the content in the international sphere, and at the UN there's been lots of documents that have been issued that talk about the human rights impacts of climate change. So actually delve down and use specific rights in language like the right to privacy, the right to equality and non-discrimination in the way that you engage with decision makers.
Fantastic, thanks, Ben. We've had a few questions that are related more to using the Human Rights Act as an advocacy tool. So just as a note for everybody, next year we'll be doing approximately 6 webinars related directly to how you can use it as an advocacy tool in particular areas. So we'll keep you posted on those, but definitely save those advocacy questions for those webinars. We have a question about, Ben, you've talked about having independent and neutral complaint processes. Do you think that organisations may need to outsource that complaints function, or can organisations still do it internally?
Yeah, good question. So, I mean, the way that, at least the way that I would come to this would be if you look at things like the right to a fair trial and what the meaning and content of that is, and it talks about decision makers being independent. That means hierarchically independent, often institutionally independent, and quite often what's as important as the actuality of independence is the perception of independence from the perspective of the complainant as well. I'm sure that's you know, they're principles that people would broadly be familiar with. So I think in the CLC context, it doesn't need to be you know, overly thought through. But I mean, I would think whether it's something like being able to outsource or setting up some kind of separate and independent committee to receive complaints could be one way to think about you know, how you might revisit complaints process. That's all offered without much of an understanding of what complaints processes currently look like within your various organisations. But for example, I mean, it's commonsensical that if there's a complaint that's made about the CEO, it shouldn't be the CEO who responds to that, or the CEO who's briefed by the board to respond. I think there does need to be some element of institutional independence, and perception is very important in that context as well.
Thanks, Ben. We have a question about functional public entities. So do you foresee not-for-profit organisations being captured as a functional public entity? So the example given is a not-for-profit organisation running a youth shelter that's funded by government grants.
Yeah, so thanks for that question. It's a good one, and it's one of the, I guess, sticky ones really around that definition of a functional public authority. I could talk briefly to the Victorian experience, acknowledging that the legislation is slightly different, but a lot of organisations that got caught up as being defined as public authorities was the term used in the Victorian context, were organisations that provided housing and shelter. So they were organisations basically which were funded by government, and where there were high levels of sort of regulation by government about how those services were to operate. And for people who are familiar with the legislation, it sort of talks about those characteristics really around whether or not services are funded by government, and the sort of level of control or autonomy that they have. So without knowing specifically about the organisation that you're mentioning there, Diane, I think that, yeah, that there's a good chance that where basically government is outsourcing services, so it's entirely funding and then it's determining how those sources should be used, I think you should give careful consideration to whether or not those particular services would be fall under the category of being a functional public or entity. Which also, to make maybe a broader point, is that and this might be relevant for CLCs, is that it's not necessarily the whole of an organisation that's determined to be a public entity. There could be specific activities that are undertaken. So let's say a particular organisation runs 10 programs. There could just be one of those programs where, in undertaking and delivering that service, that obligations under the Human Rights Act fall. So I guess just to flag that as well.
Thanks, Ben. We've got a couple of other questions, but we've hit 11 o'clock, so I'm going to take those questions on notice. Just one more for you. Could you give examples of potential human rights related risks and opportunities? The question is for community legal services, but I guess more broadly as well.
Yeah, it's a good question. I mean, I hope to some extent some of the content that I talked about during the webinar itself sort of covers off on that. I think some of the risks for community legal services, and there's kind of legal and non-legal risks that, I mean, if there are aspects of services that are provided by CLCs which are determined to be that of a functional nature, a functional public entity nature, then I guess one of the risks really is that there are legal obligations under the Human Rights Act that come with that, and failure to comply with those legal risks opens up the avenue for complaints to be made. I mean, I think more broadly, and hopefully part of what the webinar is focused on, is that there may be a legal risk involved, but more broadly, adopting a human rights approach really is around how organisations can think about enhancing the work that they provide, the work that they do, the services that they provide to clients, to make sure that it's more responsive to the circumstances of clients, and therefore more effective. So I think the flip side of that then is that that's the opportunity really that comes with a human rights based approach, which hopefully I've covered off enough during the webinar.
Brilliant. All right, well, we've just hit past 11 o'clock, so we'll wrap it up there. Thank you very much, Ben, for your presentation today, and thank you for everyone who has attended. We'll get the recording downloaded and up onto our website this afternoon for you, so thank you.
Thanks, everyone.